Gregory Taylor.
On behalf of the people.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Gregory Taylor. Mr. Taylor, please state your name for the record.
Gregory Lewis Taylor.
Thank you, Your Honor. Today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination at the very soonest date available.
I don't know if the parties are in receipt of, but the court has received, I guess, what's been entitled an affidavit of non-prosecution.
Yes, Your Honor, we were sent a copy of that.
Okay. Do people be ready to go on the 13th, or you want the 20th?
One moment, Mr. Taylor.
Would we be able to have the 20th, Your Honor?
Buckle up, guys. Today we are going straight into a courtroom moment that shifts the entire direction of the case. What begins as a routine probable cause conference immediately takes a sharp turn when the judge reveals the court has received an affidavit of non-prosecution. That single document raises questions about the witness's cooperation and puts both sides on edge, setting the tone for a tense hearing where timing, strategy, and credibility suddenly matter more than expected.
Excuse me.
One moment, Mr. Taylor. One moment. The judge will give you a chance.
Preliminary examination in person will be set June 20th, 2023, 9 a.m. That will be before Judge Fresh Hour.
Your Honor, may I respond, please?
Yes, go ahead.
We believe that the 13th would be the most appropriate date. From the affidavit, it appears to us that it is clear that the complaining witness does not want to be a participant in this. If, in fact, it turns out that there's not going to be a complaining witness, then there's no reason for them to go to the 20th as opposed to the 13th. Normally, they would ask for.
I don't know if they know that. I mean, this is yes.
As this court is very aware, we don't actually always need the victim to go forward with this case. So I would like some time to look into this, to have my victim advocate be able to speak to the victim if possible, and to be able to see if we can proceed without her. So I would ask for the 20th.
Yeah, and I hadn't finished making my argument. If I may please be allowed to do that.
Yeah, go for it.
Thank you. It's my understanding that they have heard from the complaining witness in this matter. The complaining witness has made it clear that they do not wish to continue. Further, there are other factors that are involved in here. Mr. Gregory Taylor suffers from a serious back injury to his lumbar vertebrae, which is causing neurological damage. He's attempted to put in kites so that can be seen. At the medical facilities have been giving him Tylenol. He was finally able to get a kite to put in, and they had to up it to, I think, neoproxen. Is that what it was, Mr. Taylor?
Nortriptyline.
Oh, I'm sorry, nortriptyline.
It's another one. Neoproxen is. Naproxen was what they did before. Now they changed it to nortriptyline, and they're supposed to add another pain medicine today, moxilin or something like that. But I haven't gotten it yet.
So he is suffering from serious medical issues while he's in the Washington County Jail. There's every reason to believe that the prosecution will not be able to go forward, even if they say that they think they'll be able to proceed without the complaining witness. Would rather find that out sooner than later, rather than have Mr. Taylor sit in jail with his medical issues for an extra week. This is something that they can expedite given all of the circumstances, given they have this affidavit of non-prosecution, given they have this sort of warning. I believe that in the interest of justice and the essence of preserving judicial resources, and certainly in the interest of not keeping an individual incarcerated for longer than might be necessary, that having them setting this matter for the first available date would be appropriate.
From an outside perspective, the defense pivots hard, focusing on urgency and human cost. The attorney lays out detailed medical concerns, describing serious spinal injuries, worsening pain, and limited treatment inside jail. The argument is clear. Every extra day matters. This is no longer just about legal procedure, but whether keeping defendant incarcerated longer is fair when the prosecution's ability to proceed already looks uncertain.
This is not an argument I would typically or normally make, but given all of these circumstances, I think it would be very much.
Well, and we don't usually get these, and I might agree with you, except that this doesn't say that the complaining witness, or to the extent that she is, will not testify. All it says is she doesn't want to, but she does understand that she may be compelled to. So I don't know what that means, and I don't know. And I think, in fairness to all sides, because this came in, and I don't know what communication has been had with Ms. Taylor or anything along those lines. I'm setting it within the time frame that is by statute. I don't think I'm delaying it in any way, but I'm going to attempt to be fair to both sides in regard to it. So it's 12 days out, and that's where we'll be. So I'm going to leave it on the 20th at 9 a.m.
Thank you, Mr. Taylor. I'm sorry, Mr. Taylor. If you have something to say that pertains to your case, I'd advise you not to say it. If it's something,
It doesn't pertain to my case, it pertains to the prosecution's case. She
well,
also,
no, stop. The prosecution's case involves you.
okay, well, it pertains to the witness.
Then I don't want you to say anything on this record. I'll come and speak to you. The court has made its ruling.
Okay, but sir, you didn't inform them that she also has a letter that she went through the advocate in place with the court clerk as well as the prosecution that she will not be participating, that she has absolved herself of any responsibility where this is concerned. She's not going to testify.
Okay, Mr. Brown, first of all, and I'm just going to lay this out, and maybe Mr. Taylor, you should listen to your attorney,
Okay,
because your attorney is telling you not to say anything to the court. Now you're talking about communications that you're aware of that have been made, or at least purported communications, where the alleged victim says now, unlike the affidavit in front of me, that she will not testify, which I don't know. And I'm not saying that you were interfering. It would be a little bit, I'm a little bit concerned that you know that. And so I think even more so that people ought to have an opportunity to look at this and make sure that it is not by your interference that this is occurring. So you probably should have listened to Mr. Brown and just been quiet, because that was not my conclusion at all until you started talking.
At this point, the dynamic shifts dramatically. Despite clear warnings, the defendant speaks up and introduces new claims about the witness refusing to testify. The judge's tone changes instantly. What might have been a procedural discussion turns into concern over possible interference. From a neutral observer's view, this is the moment the defendant hurts his own position, escalating suspicion and solidifying the court's resolve instead of helping his case.
okay.
So, Mr.
Bond
Taylor,
will continue. Thank you.
that you're going to that's going to change the ruling that's been made right now. So I would ask you not to make
You
any
said you're
further.
going to ask for bond, and that didn't happen either. Can I terminate Mr. Brown and request the ability to hire outside counsel from the public defender's office?
Mr. Taylor, you are always free.
Yeah. If that's what you want to do, then I'm just going to adjourn. I'm not going to set it for preliminary examination. So then what I'll do is I'll just give you another probable cause date. How much time will it take you to get an attorney?
I can't do it from in here. I'm asking to be released so that, or put on bond.
Oh, well, that won't be happening. So how soon will you get an attorney?
Just Just leave Mr. Brown as my attorney then, because then I have to
Okay.
contact my family in order to see if they can find somebody for me.
Okay, then we'll leave Mr. Brown. Do you want me to leave it set for preliminary examination? Because that's what Mr. Brown asked.
Yes, go.
You do?
Yes, please.
Okay, what?
Yes, sir, please. Thank you.
All right, I'll leave a preliminary examination in place. Mr. Brown, you're still on the case.
Thank you. I do appreciate that.
You're
Thank you, Mr.
welcome.
Brown.
All right. It's been a pleasure. Thank you, folks.
In the final stretch, the defendant attempts a bold move by trying to fire his public defender and asking for outside counsel, even suggesting release to make it happen. The judge shuts that down quickly, keeps the attorney on the case, and leaves the hearing schedule intact. The court closes with authority and finality, making it clear that impulsive decisions won't override procedure.